Hi, everyone. Thank you all so much for joining our webinar. We are just getting started. Folks are trickling into the meeting, so we will give it a few minutes for everyone to assemble and get started. All right, I think the stream of entrance to the chat is slowing down a little bit, recognizing that folks may continue to trickle in just as schedules change and life happens. But I do want to be respectful of everyone's time, given how busy and packed everyone's schedules are. So we're going to go ahead and get started. Thank you all so much for joining this webinar on the federal legislative response to the coronavirus, hosted by the National Women's Law Center and the Legal Network for Gender Equity. So just a quick walkthrough of what we're going to be talking about today. So we have a series of panelists from the Law Center to talk about the substantive provisions of the Families First Coronavirus Response Act, or the FFCRA. This is, apologies in advance for an acronym-filled, maybe too filled presentation, but we didn't pick the acronyms, we promise, and the CARES Act. So those are the two major pieces of the coronavirus response that we're going to be talking about today. And then we also have perspectives and stories from practitioners in the field who have been working with clients and on the ground to implement these laws that have come through from the federal level, and then also how those are interacting with the state laws that already exist. And then we're going to wrap up with a question and answer. Many thanks to you, all of you who submitted your questions in advance via the registration link. Some of your questions, I think, will be answered and addressed throughout the course of the presentation, and then we will do our best to get through as many of them in the Q&A period as possible. If there's time at the end, we will happily take more, so if things come up, do feel free to submit them in the chat, and we will do our best to address them. And if not, we're happy to follow up with people afterwards, and we will be circulating resources and links both from the National Women's Law Center and from some of our partner organizations who have helped us put together this presentation, which could hopefully serve as a jumping off point for all of you to take this information and turn it around to your work in the field. So quickly, Ellie, if you want to head to the next slide. I'm going to introduce our really excellent team of panelists who are both from the Law Center and then from our partners out in the field. Head to the next slide. So my name is Laura Narewski. I am a fellow on the Workplace Justice team at the National Women's Law Center. And in this world, I focus on the paid leave and paid sick days provisions. We're also joined by Melissa Botea, who's the Vice President for Income Security and Childcare at the National Women's Law Center. And our last NWLC teammate is Amy Matsui, who's the Senior Counsel and Director of Income Security. And then we are also very happy to be joined by Elizabeth Kristen from our friends at Legal Aid at Work out in California. Elizabeth is the Senior Staff Attorney and Director of the Gender Equity and LGBTQ Rights Program. We are possibly going to be joined by Sheila Medali from the National Legal Advocacy Network, but life happens, and so Sheila is currently a little tied up, but we'll see, holding our hopes out, but she certainly has resources and stories that we can share and follow up with folks afterwards. All right, if you want to head to the next slide. Quickly, we're going to start with I promise as brief as possible, walkthrough of the emergency paid sick days and paid family leave provisions under the Families First Act. So it's a little difficult to describe because, as some of you know who work in this field, Medical leave, the FMLA, is sort of a term of art that's really specific to the US and is not universally applied or used in terms of a definition. So quickly, by way of table setting, paid sick days is used under this law to refer to the short-term leave. That's things like a couple hours to go to a doctor, a day off if you have the flu, and family and medical leave is the longer-term leave, traditionally in the US, unpaid under the FMLA. In the federal coronavirus law, it is not actually family and medical leave. It's really only caregiving leave, but we're going to address that later. I just wanted to give a quick definitional table set. So under the Families First Act, there are both family caregiving leave and then sick days. So sick days, employees are entitled to 2 weeks, which translates to 80 hours for full-time workers and 2-week average for part-time workers, of job-protected paid sick leave who are unable to work or unable to telework because they're complying with government-issued quarantine, healthcare-issued quarantine, they're getting a diagnosis for COVID, and then to care for someone who's under any of those regulations, and then also to provide care for a child whose school or place of childcare is closed. Part-time workers are covered by the emergency paid sick days provisions, and there are special regulations for how rate of pay is calculated for part-time workers, which is something that we'll address in a second. So while part-time workers are included, the law does exempt employees who are at corporations, private employers with more than 500 employees. That's the big grocery store chains, that's some of the big box retail stores. And there's also a small business exemption, a hardship exemption administered through the Department of Labor for employers with fewer than 50 employees. So the combo of the large employer exemption and the small employer hardship exempts a very large number of employees, I think up to 106 million employees, from the protections of the paid sick days and paid family leave. There are also exemptions for healthcare providers, emergency responders, and executive branch employees that are on a discretionary basis by employers and the Department of Labor. So the leave guarantees full pay up to a maximum of $511 a day if you're caring for yourself, so that's reasons 1 through 3 on the slide, and 2/3 rate of pay if you're caring for someone else. So that's reasons 4 and reasons 5. These rights are accessed on an employer to employee basis, so it requires employees to know what their rights are and to ask for them from their employer. This does not have a top-down external mechanism. There's a real burden on the employees. However, there is a private right of action under the law. Failure to provide paid sick leave is considered a violation of the FFCRA minimum wage. And so employees have the right to sue if their employers deny them leave, even though they fit into one of the previously stated categories. All right, next slide. So the paid family and medical leave is relatively similar in terms of its coverage and exemptions. There's a similar 500 employee, 50 employee, large employer, small employer exemption. But the paid family leave, which is not medical leave, it does not apply to care for oneself if you have personally a case of COVID-19, need longer term care. It is only to provide care for others in the cases of a COVID-19 diagnosis and need for care. But it does provide 12 weeks of job protected paid leave, paid at 2/3 the regular rate of pay, up to a grand total of $10,000. And similarly to the paid sick days, it is, there is a private right of action if the employer is otherwise able to be sued under the FMLA. So there's the 50 employee private right of action threshold for the FMLA, and the same penalties and potential recovery for employees applies under the extension of the FMLA to emergency care. We have already seen cases reported of people who are suing their employers under the Families First Coronavirus Response Act. Bloomberg Law has been covering several of them for denial of paid caregiving leave in cases of COVID. So with that, I'm going to turn it over to Melissa to talk about unemployment insurance.
Great. So Thanks again for tuning in. Speaking of alphabet soup, the unemployment insurance provisions in the CARES Act, I think, are essential and very important, and also very complex. And so I want to quickly just walk through the 3 new programs that were created, and then be happy to sort of take questions and talk about how all this interacts with all the various other alphabet soups that you're going to hear about. So the CARES Act created 3 new unemployment insurance protections, all of which are fully federally funded. The first one I'm going to talk about is pandemic unemployment assistance. And I think it's because this one is covering people who you're not used to hearing are covered by unemployment insurance. And in many cases should be, because they're misclassified, but that's a story for another day. So in this case, if you have COVID, or a diagnosis or symptoms, or seeking a medical diagnosis, if you have a member of your household who's been diagnosed, if you're providing care for a family member, if you have primary caregiving responsibilities for a child, or your child care provider or school is closed, that's me. If you cannot reach your place of employment, if you are self-quarantining under the advisement of a healthcare provider, if you were scheduled to start a job, but now you no longer can because of the health emergency, if you have become the primary breadwinner after the head of household has died from COVID, if you've had to quit your job, or if your place of employment is closed. So there's 10 reasons there why you would be eligible for pandemic unemployment assistance. And this applies to self-employed individuals and independent contractors, again, which is not usually the case for regular underlying unemployment insurance. And you're eligible for up to 39 weeks of benefits. Next slide, please. The 2 other forms of unemployment insurance that you can get through the CARES Act are the Pandemic Emergency Unemployment Compensation Program. This is 13 weeks of additional benefits for individuals who have exhausted their traditional UI after July 1. So you all know that unemployment insurance is a federal-state partnership. States have different systems, different sets of rules, and the federal government typically steps in and pays things like extended benefits, but typically workers are supposed to exhaust their state UI benefits first, which have varying rates of generosity and eligibility. So this is paid at the state standard benefit rate, and it only applies to people who would otherwise qualify for the state traditional UI. And then finally, and this has been the source of a lot of controversy in the news, so this is a problem you've probably heard about, the Federal Pandemic Unemployment Compensation Program is an extra $600 per week that is paid out on a weekly basis. So if you're already getting the underlying unemployment insurance program, that $600 will come on top of that baseline benefit to the extended benefits that you would get, as well as to if you are an independent contractor, a gig worker, or someone who is receiving the PUA, Pandemic Unemployment Assistance, you get that $600. And so that is scheduled to expire towards the end of July. And so I think there's a question going on right now about what will happen to the program, as many employers have claimed, we would argue wrongly so, that people do not want to return to work because they are getting more from unemployment benefits than they are, when the reality is actually oftentimes there's lack of caregiving available, there's lack of personal protective equipment, and other kinds of issues that will be addressed throughout the course of the webinar. I'll stop there, and again, we'll get into further detail and depth later as we go through the interactions of these programs.
Great, thank you so much, Melissa. Now we're going to turn it over to Amy to talk about, what are they called now? The economic impact payments? They've had 15 names in the last week.
Thank you so much, Laura. And you're right, the IRS has called these payments economic impact payments. Under the CARES Act, they're technically called recovery rebates. And then your clients, and in the news, you may have heard these called anything from stimulus payments, direct cash assistance. But what everyone is referring to are cash payments that are worth up to $1,200 maximum per individual. And that means that for a married filing jointly couple, the maximum that they could receive for the 2 of them is $2,400. On top of that, for each child that is claimed as a dependent, age 16 and under, those people can also receive a $500 payment. So just a couple of basic points of information about these direct payments. So one, you'll notice that I use the word maximum, and that is because as people's income rises, the amount of the payment declines. So that's just something important to keep in mind. As the slide notes, the maximum payment is available for single individuals who are making less than $75,000, and the payment cuts off once the single individual makes more than $99,000. And those income levels are tailored for people who file as head of household. So that means they're filing as someone who's claiming a child, but they're the primary breadwinner in the house. And the income limits for a single person are doubled for a married filing jointly couple. A couple of other things that I want to mention about the payments are that you'll note that I said that for children who are eligible for the $500 payment, the cutoff age is 17. And that means that older children, college students, it could be children with disabilities who are living with at home, are not eligible to receive this additional $500 payment. This is also important because if someone is claimed as a dependent on someone else's tax return, they cannot then claim an economic impact payment in their own right. Another really important exclusion under this, this CARES Act benefit is that for a household kind of claiming what we call a tax filing unit, everyone in the household has to have a work eligible Social Security number. And so that means that people who are filing with an individual tax identification number, this comprises a fair number of immigrants who are working and paying taxes, but their entire family is ineligible to receive an economic impact payment or a rebate. Kind of the other major thing that I want to touch on in this conversation about the economic impact payments is what the process is, because that has been fast, chaotic, and really hard for a very understaffed and underfunded IRS to implement over the past several weeks. So there were kind of a couple of different, just call them buckets of people who are receiving the economic impact payments. And the first of those are people who are supposed to be able to receive the payments automatically without taking further action. This includes people who either filed a 2019 or a 2018 tax return, and all of the eligibility criteria are based off the 2018 or 2019 return. And so if someone filed a tax return for tax years 2018 or 19 and included bank information to get a direct deposit of their refund, they should be able to automatically receive an economic impact payment that is directly deposited to their bank account. In addition, for individuals who receive Social Security benefits, railroad retirement benefits, certain kinds of veteran benefits, or supplemental security income, they should, if they are not claiming dependent children, be able to receive these payments automatically in the same form that they receive those benefits. That could be as a paper check, or it could be as a direct deposit. So what happens for people who don't fall into this particular bucket? So that is the group of people who need to take additional steps in order to receive their economic impact payments. So this includes people who filed a tax return but didn't include bank information. It includes people who usually don't have to file tax returns, but who, for example, are receiving Social Security or supplemental security income, but are claiming dependent children. Since they haven't filed a tax return, they need to provide information around them. And then there are also a whole host of people who have incomes that are too low to be required to file a tax return, but still need to get information to the IRS in order to receive economic impact payments. So what the IRS has done, as many of you may know, is set up two online portals. One that's for people who already filed tax returns and just need to input their bank information. And then one is for people who don't and didn't file and don't plan to file tax returns, but need to give information about dependents. They can also give information about, if they don't want to have the payment go to a bank account because they don't have one, they may be able to give information about a debit card or that is refillable, and there are a couple of those that are available that, for example, the CFPB, the Consumer Finance Protection Bureau, has noted as being kind of reputable and good. So in addition to there being kind of these processes for people to get information in order to facilitate these payments, we're in kind of a game where the IRS was building the bridge as they were walking over it. And what this means is that people could put information, for example, about their bank accounts in, but if the IRS has already sent their check, they're not going to take that information and they're not going to resend a check. So we also saw that there were deadlines for Social Security beneficiaries, railroad retirement beneficiaries, and people who get SSA and veterans benefits. If they did not claim their children on the IRS webpage by a certain date, those children are not going to be accounted for in their economic impact payments. So this is kind of a mess, and questions that you may be getting from clients or folks in the field is, now what? So the upshot for that is that if, for example, your clients or people that you work with have already gotten a letter from the IRS saying, hey, we sent you either a payment as direct deposit, a check is in the mail, or people are getting their payments and realizing that their payment is not augmented for the number of children that they have, or it's incorrect based on their 2019 data. The way that people can fix or reconcile this is through the tax filing process for tax year 2020. Unfortunately, for a lot of people who really need this influx of cash right now, that is not going to happen until early next year, until 2021. So a couple of other things just to flag for folks is that based on, as I mentioned, there can be true-ups, reconciliations, adjustments for 2020. People should only be getting adjustments for increases that they should have received. They should not be getting clawbacks. You have seen that there's a lot of confusion in the press about whether any of the payments are going to be taken back. For example, if there were people who were deceased. There are, for people who have trouble filling out the online portals, they may be able to get assistance through some volunteer income tax preparation sites that are operating online, and information about that is available on the IRS's website. No one is available to answer the phones at the IRS. And then last but not least, people should be aware that, like every tax filing season, but particularly now, fraud is a problem. No one from the IRS will ever contact an individual on the phone or through social media or email requesting bank information or personal information. So if your clients are getting that kind of contact, it is not legitimate and they should not respond. So with that, I'm going to close out and turn it back over to Laura. Thank you.
Thank you so much, Amy, and thank you in particular for the note, which weren't true, but is very necessary about ways to prevent against fraud in this context. So with the sort of baseline of the substantive provisions handled, I want to quickly make a note and say many thanks to our friends who are watching and making sure that we stay honest. On a previous slide, discussing the small employer hardship exemption under the paid leave and paid sick days, I should be very careful when I say that that only applies, this paid sick day exemption for small businesses, 50 employees or less, only applies in the case of caring for childcare or schools that's closed. The small business hardship exemption is not so broadly applicable that it applies to individuals who themselves are sick or quarantining. So it's an important distinction. So many thanks to those of you who are keeping us honest. And with that, I want to welcome and say many thanks to Elizabeth Kristen at Legal Aid at Work, who is one of the people who's been dealing with how this pandemic and then also how the legislative response has impacted it from the very beginning. She can talk more about this, but Legal Aid at Work has been really on the front lines of handling employee needs and individual protections for a while, because this hit California so hard and so fast and so early in the pandemic. So we are very happy to have her to share perspectives with us. And so with that, I will turn it over to Elizabeth.
Thanks, Laura. I'm really happy to be here today with our friends from the National Women's Law Center, and I know so many of my colleagues are attending this webinar, and so hopefully they will also text me and chime in, and I can pass that along to all of you, because this has really been a team effort at Legal Aid at Work. We have been involved in a rapid response to COVID-19 since probably early March. So I want to tell you just a tiny bit about our organization. Our organization is a nonprofit based in San Francisco. We've been around since 1916, but since the 70s, we've focused predominantly on employment discrimination issues for low-wage workers, and we do help folks who are undocumented because we don't accept LSC funding. And so our programmatic orientation is really robust in the sense that we have a disability rights program, a work and family program, wage theft, unemployment insurance, national origin, workers' rights clinics. And so in this type of crisis, this was actually a real strength for us, because when we began collaborating programmatically on our FAQs, which are on our website, legalaid@work.org, we had someone from the disability rights program able to weigh in around what would be the disability aspects of these, questions that people were going to have about dealing with COVID. But we also had expertise on unemployment insurance, on family medical leave, and in all of the discrimination issues that might be arising. And so the other thing that I think was helpful is that our office, and as you all know, San Francisco was one of the first areas to lock down. We went on a virtual platform pretty early again, like the second week in March. And so all of our workers' rights clinics went on a virtual platform. Those are clinics that provide direct services to low-wage workers throughout the state. And our work and family helpline, which receives, thousands of calls sometimes during the year, was available and was ramped up. And so just to give you a sense of the volume that we were receiving in the first month, the Workers' Rights Clinic got more than 1,100 calls in basically a 1-month period. That's almost the number of clients they serve in a year usually. We also had a similar increase in volume on our work and family helpline. And so this, as you might imagine, not only shows the extent of the devastation to workers and the questions that people have and the fear and the confusion that has been rampant among workers and low-wage workers and undocumented workers in particular. But as I'm sure many of you experienced as well, it also was the struggle of people who were the ones who were providing the services also adjusting to being remote, to dealing with the online platforms, to figuring out the technology. And so I think we ramped up really quickly, and I'm really happy that we were able to provide so many services to low-wage workers. But I think it's been a pretty heavy burden for a relatively small office, and we've been trying to absorb additional help as we can, and have certainly gotten that. But it's been a really kind of intense period for us, and obviously more so for our clients. And so I want to talk just a little bit about some of the kinds of things that we're hearing about, and then tell maybe a couple of client stories, and then I know we want to leave plenty of room for Q&A. So as you might imagine, we're getting a lot of questions about unemployment insurance. There's been questions about gig workers, misclassified workers. You all probably know that here in California, we have a law that was supposed to remedy a lot of the misclassification for people like Uber and Lyft drivers. But because of the timing of when that took effect, there was an infinite number of questions about when should people apply for UI? How should they prove up their earnings? And how should they address applying for California unemployment insurance as opposed to applying for the pandemic unemployment insurance when that became available? There, as you know, had been pretty robust periods of high employment and low unemployment in California. And so our unemployment insurance practice had not been as active as it has been in the last month and a half. And so it's been also a matter of training people up to make sure that they're fully aware of the unemployment insurance process. There's been tons of questions about how to get through to our unemployment insurance agency in California. I know I've been hearing these stories, and you've been hearing them in your states as well. People calling 25, 30 times an hour trying to get through to unemployment insurance. I think some of those problems are easing up, but it's still really, really challenging. And it's especially challenging for people who are limited English proficient, and the online forms may not be available in their language. So that's been hugely challenging. The other issue has been workplace safety issues. People are concerned about having to go to work in conditions that they think are unsafe, or people who are being told that they're essential workers but think that maybe they're not, and that they are concerned about whether they have to go to work in those circumstances when they have concerns about their own health. There's been a lot of questions around disability accommodations, how to address the fact that either you have a disability that makes you particularly vulnerable to COVID, and so you need accommodations of remote work or something else, or maybe you're caring for someone who has disabilities that are going to be perhaps affected more by COVID. So those have all been questions, as well as the wage replacement and the job protection for people who need to take time off work because either they're quarantining, because they were exposed to COVID, or because their childcare isn't available or their child's school has closed. This obviously had a devastating economic impact on people in terms of how could they even navigate their day-to-day lives and go to work while they're also trying to basically run a school or a childcare out of their home. I know we're hearing some of these stories about medical workers who have to go to work and they're having to find someone to sit with their children. They're having to find someone to school their children or help their kids navigate school. One of our colleagues was in the San Francisco Chronicle recently with a story of a woman who had asked her employer to take time off to go to her kid's school to pick up a Chromebook or a laptop so that her kid could basically access their schooling online, and lost their job just for asking about it. And so I think workers who are already strained are, of course, even more strained, people who are going to work. And then people who aren't going to work or lost their jobs or had their hours cut are also obviously economically strained. We're hearing from farm workers who didn't have PPE, who are essential workers. I'm really happy to see that finally farm workers kind of on the front line of some of these food supply issues are getting some attention. And we were able to kind of help try and intervene to make sure that's happening. And then, of course, we're hearing a lot from our undocumented workers who basically are cut out of many, if not all, of these financial support programs. Our office was part of a coalition that led some advocacy here in California so that our governor announced a fund that will provide some funding for undocumented workers, but the details are still being worked out. And so it's not yet clear how undocumented workers are going to be able to access this and how we're going to be able to protect them as well, so that we're not creating a database of the undocumented that would be used for bad and nefarious purposes. So in addition to sort of the direct client services that we've been providing, we've also been working in a lot of different coalitions, trying to do policy advocacy at the local and the state and the national level to try to advance these things on a pretty fast moving basis. My colleagues have been appearing at town halls, which has been a really interesting forum for us. Different state and federal legislators have been holding town halls virtually, and we've had our colleagues participating and explaining the Family First Coronavirus Response Act and the CARES Act, and providing, some live Q&A to constituents of these legislators. And then we have been, engaging in a lot of different media appearances, as I'm sure you all have as well, trying to get the word out about all of these different new laws. And as I'm sure all of you all, trying to keep up too with the rapid change and the rapid updates in what's happening. And it's a really, again, kind of an interesting paradox to have this dramatic change, these huge responsive laws that I think we're hoping will set the table for some future improvements at the federal level, yet at the same time seeing so many of them being time limited. And so we're having to learn this tremendous amount to be responsive to our clients, and then maybe these are all going to evaporate at the end of the year. So it's been difficult, challenging, interesting times. Of course, really, really difficult for our low-wage worker clients. And so I just want to give a shout out to all of those workers who are out there suffering, trying to keep things together for themselves and their families, and knowing that, all of us, I'm sure, on this call are going to do what we can to help them.
Absolutely. Well, thank you so much, Elizabeth, for sharing some of the great work that you've been doing at Legal Aid, and what what you and your partners out in California have been helping out with. So we really appreciate that. We now are going to turn to a Q&A, and those who've been following along closely in the chat will see that you can raise questions in the chat, but we are going to start with the questions that were submitted ahead of time in the registration, and we will do our best to get to as many of your questions as we can. And just to reiterate what was helpfully noted in the comments, the presentation is being recorded and will be sent around, and we also are going to share some additional resources that can hopefully help to address questions that we might not have quite enough time to get to. But I want to start with something that Elizabeth raised and that Amy addressed, but I don't think we talked about in the context of UI or paid sick and paid family leave, which is how the laws impact and apply to or don't apply to non-citizens or people with mixed or different immigration status. So I can start by saying that in the context of paid sick and paid caregiving leave, because those are essentially extensions of, in the context of caregiving leave, the FMLA, and that paid sick leave is granted through your employer, there are no specific carve-outs or pieces of the law that address individuals with different immigration statuses. So that is a employer-employee relationship, which again does nothing to protect people who might need additional protection from employer discrimination or retaliation based on the on immigration status, but there is nothing specifically exempting people who are undocumented from protections under those laws. Melissa, I don't know if you have, you want to touch briefly on how the 3 different UI provisions either do or don't protect people who are either not citizens or undocumented? I think you're still on mute.
Can you hear me now?
Yes.
Okay, great. Sorry about that. I can touch on that, and Elizabeth should feel free to augment. So unfortunately, undocumented immigrants are not eligible for any form of unemployment insurance. In general, for immigration status, there are 2 periods that are relevant. There's the period of application and the period of work history. So the workers have to have a valid work authorization during the base period, which is the time that they're applying based on their work history of, and at the time that they apply for benefits, and then throughout the period that they are receiving benefits. And if a worker meets those requirements, they should be able to access unemployment insurance. But again, unfortunately, undocumented workers are not able to access those provisions.
Thank you so much. And one of the partner resources we will send addresses how we, what additional protections or benefits maybe at the state level might be available to undocumented immigrants. Elizabeth, I don't know if you have anything you want to add about maybe some of the things California has done, some of the additional steps that have been taken.
Yeah, we are obviously really concerned about our undocumented workers here in California. There is not an ability to access unemployment insurance in California either, but undocumented folks can access some of our other pay support benefits like state disability insurance, paid family leave. Those do not have the same kind of work authorization requirements that UI has. And then we're working on getting this undocumented workers fund up and running. It's a significant commitment of money, but when you think about how many undocumented workers there are in California, it's not really enough to provide economic support. And so we're hoping to continue our advocacy and improve the ability for undocumented workers to access some financial support during these difficult times for them and their families.
And I'll just add from an advocate's perspective, because I'm not a lawyer and I'm not working at the state level, but just from an advocate's perspective on undocumented workers and immigrants, like one of the things I think that this whole pandemic has underscored, hopefully for a lot of people, is this concept of shared fate, and this idea that we are as strong as sort of the least progressive state when it comes to all of this. And the more people that we exclude from provisions that enable them to stay home, to take care of themselves, et cetera, the more everyone is at risk. And so in addition to it being a moral imperative, it really is a public health and economic imperative that we fix this and get it right.
Absolutely. Thank you for emphasizing that. I think it's important. Sometimes when we're in the world of policy advocacy, it can be important to take a step back and make sure we really think about what we're doing as a society and how we're what we owe to each other, and how we're really making sure that the laws that we're impacting get the maximum amount of help to the most people. So we've gotten a lot of questions both in the registration and a couple in the live chat about gig workers and independent contractors, and also misclassification, which I think impacts all of these different areas differently. I'm thinking in some areas it's probably a little bit easier, and in some parts of the law it's a little bit more complicated. Right. You know, unemployment insurance is a very simple, very broad brush. We can have one quick answer and we'll wrap this up in 5 minutes, I'm sure.
That's right.
But just to start with, on the paid family and paid medical leave, you can tell that I'm taking a moderator's prerogative by answering the simple parts first. Independent contractors are available to apply for, can claim a tax credit that's available to them for time that they're unable to work because of any of the qualifying reasons under leave. So if you are self-employed, that's sort of your version of that, the same way that employers are applying for a tax credit up front to help them ease the burden. That same tax credit is available. I don't know who wants to kick off this fun question next about gig workers and independent contractors. Melissa, can I kick it to you?
Sure. We got 2 questions in the Q&A that related to this as it regards to UI, so I'll try to take both of them. The first one is around whether or not, if your hours are reduced, but you're not sort of fully unemployed, can you still access? And the answer is yes. You just need to self-certify that you've lost those hours and apply through the normal PUA process, and you should be able to get some degree of income support through unemployment insurance. So that one's fairly straightforward. It's partially or fully unemployed. The second is about misclassification. I connected with some colleagues at NELP ahead of this just to check in. And what they are encouraging is that if an employee is how to put this, basically in many states employees should be classified as employees, but they are misclassified. They should be supported in applying for regular UI. They'll get more benefits, and because they'll get their underlying UI benefits plus the $600. So they should be supported in that. If that doesn't work, they should go to the pandemic unemployment assistance program so they can at least get something, and be able to have the income security they need during this time. I did not ask them the specific question about whether or not this will affect someone's ability to get properly classified later, and so I can follow up on that particular question that someone asked.
Thank you so much. This is a complicated issue that grows ever more thorny.
Oh, sorry. The other thing that they mentioned, if you're doing policy advocacy, is that states should be encouraged to streamline their applications and request pay data in bulk from major companies. So for states that have passed formal exemptions for unemployment insurance, for example, Uber or Lyft or app-based workers, that PUA will still provide the crucial benefits in the meantime.
Great, thank you. We also got several questions on workers' comp and individuals who are worried they're going to be required to go back to work when either they or someone that they're caring for or live with either has a serious medical condition pre-existing COVID or is otherwise protected under the ADA, or they're already on FMLA leave. There are a lot of intersecting and overlapping concerns with people who have pre-existing medical conditions. So I don't know, Elizabeth, if you want to talk a little bit more about people who might otherwise be protected under the ADA and how the new federal laws interact with the existing ADA protections.
Yeah, I wanted to first take the workers' comp question, which I think will probably be a state-by-state answer. And I would hope that workers who have exposure to COVID at work would be able to apply for workers' comp. That is going to be the case in California. The Workers' Comp Appeals Board issued a notice in April specifically saying that workers' comp injuries caused by COVID that arise out of and occur in the course of employment are compensable to the same extent that other compensable injuries happen at work are. And so you have to show that it's job related and you'd have to show that it either, caused or exacerbated a pre-existing condition. And so those are forms that folks have to file with their employer, and there is forms, there's information on the Workers' Comp Appeals Board. So that's, I think, workers' comp, and I don't know that all states are going to take this position given some of the extraordinarily dangerous positions, I think, that some states have taken about some of the workers. With respect to workers with disabilities, the Americans with Disabilities Act, and in California, our state law counterpart, Fair Employment and Housing Act, still exists, still applies, still provides that workers are entitled to reasonable accommodations for their disabilities. So, but there is always this question of, will the employer be able to establish an undue hardship? If someone needs to basically be absent from the workplace altogether because it is just too risky and there's no way that they can take enough precautions with PPE to be at work because of their condition, but their work actually requires them to be physically present, an employer probably will be able to show that they can't accommodate them. And so I think some of these situations are going to be really difficult for people that I know, especially low-wage workers, are often faced with these really tough choices about, I need to put food on the table, I need to feed my family, have to go to work, there's no way I can get an accommodation that will help, and yet I'm kind of taking my life in my hands to go to work. And so I do think people are going to continue to face this. I hope that employers who can provide these kinds of disability accommodations will provide them. And I did want to make a quick shout out for employer best practices. If we're all hearing any, and I know it's sometimes easier in office environments, but I did want to note that in our office, they adopted a policy that people who have caregiving responsibilities need not take any leave as long as they work 20 hours during the entire work week. And so I hadn't heard of a lot of employers adopting those kind of policies. Obviously, in office environments, a little easier than a grocery store or something else. But I just wanted, if other folks, if we have time, have heard about some employer best practices, I'd love to hear some so that we can spread a little bit of good news as well.
Great. Yes, if folks want to follow up with us afterwards, we'd be happy to gather those and circulate them so that we can all be in touch about the good things that are going on, which sometimes is nice to throw out there. We have a couple tax questions. So Amy, I'm going to turn to you. Quickly, we had a question asking if we could talk about the nonprofit employers tax credit.
So this is not one that I'm super familiar with, so I'm going to just kind of give broad strokes, and then maybe we can send some follow-up resources. So I think what you're referring to, and forgive me if I'm misconstruing the question, some nonprofits were able to claim through the PPP program. Is that what you're referring to? So some of them were able to claim small business loans that are through SBA that then are converted into grants for the purposes of kind of paying payroll and utilities and things like that. And there is obviously some interplay between the tax credit that people can claim against their employer portion of payroll taxes. So there is some interplay there about which benefit the nonprofits are using in order to kind of keep the doors open and keep payroll liquid. But that's kind of all I'm comfortable talking about at the moment, but we'll be happy to send any resources that we have to give more information about that.
Great, thank you. And then hopefully 2 rapid fire questions about the applicability and phase out levels of the tax credits. So 1, does the child payment only go to those below the income max for the main payment? Or do you get the child payment even if you are above the $75,000?
Yes, so the income cutoffs, so just to kind of be clear, the maximum of the economic impact payment is available to people who are making $75,000 and above, and the amount gradually decreases until you hit $99,000 of income, at which point it cuts off. For people who are claiming children, there's a small income bump up associated with that. So if someone is making over $75,000 and claims a dependent child 16 and under, they should get kind of a slightly reduced portion of $500 added to their prorated payment for themselves. So they will get slightly less than $1,700 if they are, if they're claiming for themselves and one child, if their income is above $75,000, but they will get payment for the child as well.
Great, thank you. And then we had a question about employer immunity that came through the registration, which seems like a complicated but topical question that I thought it would be good for us to address. I don't know if anyone on the panel really is burning to take this one, but just for a little bit of table setting before we really dig into the nuts and bolts. There have been several news stories in the past couple of weeks on proposals that have not yet taken shape, but that are floating around the Senate for employer immunity if an employee gets sick while on the job. There are some blanket immunities, there are some more limited immunities, there are some parallel protections that might be something akin to what we would see in a natural disaster. But if anyone on the panel, Melissa, your face lit up, but I can also let someone else take the question on immunity for employers in this time.
I don't have information to share on sort of the current state of affairs of what is in law right now. I will just say that negotiations are ongoing, particularly as you noted in the Senate, with some Senate Republicans, especially Mitch McConnell, saying that a condition for some of the other aid to states and struggling families would be some form of employer immunity. And that conversation is very live right now in Hill discussions. And I'll just stop there.
Yes, I think that will be one of the things to really keep eyes peeled on, as it will have the potential to really dramatically impact the efficacy of these laws on the ground and whether or not these quote unquote protections that we've implemented actually have any say in making people's lives better and safer, because as we all know, a law is only as good as its ability to be enforced. I do want to quickly turn to Sheila, who has joined us. I think we had a time zone mix-up, so I want to really sincerely apologize to all of you, because Sheila has all kinds of really terrific insights that she can offer and provide. So I'm going to put you on the spot, Sheila, and also I think maybe give you the first stab at our wrap-up question, which is, what can attorneys do right now? What can we do on the ground? How can we help people? And how can we take this information that we have and find a way to best help those in need? So thank you for joining us, Sheila.
Absolutely, and I am so sorry. I think this is a very chaotic time, including Zoom time zone coordination. So my apologies, but I am really grateful to be able to be here with all of you and speak for a couple moments. So my name is Sheila Medali. I'm the co-director of the National Legal Advocacy Network. We're a national organization that really uses legal strategies to enhance the capacity and sustainability of the low-wage worker movement. And so we've been working closely with worker centers throughout the country who've been on the front lines organizing low-wage workers during this COVID-19 pandemic. And, I think what we're seeing is, often when people talk about frontline workers, we tend to think of doctors, not the low-wage factory workers, retail workers, delivery drivers, domestic workers. But these workers are being told they're essential, are being told they must risk their health to work, but also being told that they're not worth $15 an hour. And a lot of the problems we're seeing right now are not new. They're the problems that have existed always in low-wage industries. So unsafe working conditions, subpar wages, a lack of benefits, lack of job security, discrimination, and as always, retaliation for or against workers who do organize. During COVID, we've seen this kind of take on new forms. We've seen, a lack of notice about workplace closures, workers being forced to work in unsafe conditions without PPE, workers being denied their right to paid sick days or family leave, increasingly hostile working conditions and environments, and an increase in retaliation, especially against undocumented workers who are demanding health and safety protections. And this is all in addition to the struggles that people are facing, paying rent, feeding their families, fighting off debt collectors, and taking care of their health. And we see this having a really disproportionate impact on workers of color, especially Black workers who are facing the highest rate of infection and death from COVID-19. And so I'm sure, as was covered extensively by my brilliant co-panelists who are on time, a lot of the benefits, the new benefits afforded under the FFCRA and CARES Act still, have many cracks in them and exclude many workers, including undocumented workers, people who switched employers recently, people who work in larger companies with more than 500 employees or less than 50. On top of that, we've seen OSHA not issue any really specific COVID-19 requirements or take an active role doing on-site inspections during the pandemic. And as a result of this, what I would say is largely a failure of our federal government to take care and protect low-wage workers. Individuals, communities, advocates, and state policymakers have really had to step up during this moment. And so we really see a crucial need for attorneys to kind of step up and help support workers who are organizing despite all odds, to enforce workers' rights through litigation, and to work with worker advocates and organizations to strengthen workers' rights and protections on a state level. And so at NLAN, part of what we're doing and invite people to join us in is we're kind of expanding our national legal referral network as we anticipate an increase in litigation as more and more workers are going back to work and exposed to unsafe conditions. We're looking for volunteer law students and attorneys to partner with us on a series of online legal clinics that we'll be running hopefully several times a week to connect low-wage workers with information about the kind of complex laws and rights that may be afforded to them. And then also working with NLAN to kind of identify and use really innovative legal theories so we could be bold in this moment and really push the boundaries of what is possible through the law and through organizing in order to really support the work that people are doing on the ground to advance workers' rights, safety, and dignity.
Well, I don't think we could have ended on a better note. So thank you, Sheila. And the work that NLAN is doing is really critical in this time, as is the work being done by Legal Aid at Work. And it is so valuable to have perspectives from the ground out in California and in Illinois. And I'm sure many of you on the call are hearing different stories from the states that you are in. So many of these programs are implemented on a state-by-state basis, and we are still trying to untangle the web of how the federal laws and the state laws and the local laws and all these different areas are intersecting and where they work well together and where sometimes it's not clear how and if they work together. So thank you very much. We have 1 minute left. Melissa, Amy, Elizabeth, if you have any last words, we'd be happy to hear them. And then we can wrap up.
I'll just say thank you for joining us. Thank you for everything you're doing on the ground. I just want to echo everything that Sheila said. I work on childcare issues as well, and we're regularly getting stories in from, these women and caregivers on the front lines, from parents who are struggling with finding care, who are frontline workers, from lack of sanitation conditions. It's a mess out there, and the work that you all are doing to represent people to make sure they can access their rights, to untangle this web, is so valuable and so important, and we're really privileged to be your partners in doing it. So thank you.
Absolutely. All right. Well, I recognize everyone has busy lives and busy schedules. As we said, we will follow up with the presentation, and we have a series of resources on the National Women's Law Center website, which are a little bit more policy focused. NLAN has resources, Legal Aid at Work has resources. I think in the chat, we dropped some resources from our partners at NELP. And there is a lot of good information out there, and we want to be a resource to you as you continue to represent clients and work with people on the ground. So if the Law Center can be of service, if any of our panelists can be helpful, we want to be there as partners and find a way to help each other through this. So thank you all so much. Thank you to my incredible group of panelists. It is a delight to be able to learn and hear things, and maybe one of these days I'll understand unemployment insurance, but hopefully we're all one step closer to understanding a little bit more.
There's
so thank
5
you all.
people in the country who do.
Great. Well, thank you all so much for joining us. And take care, stay safe, stay healthy, and we will get through this together.